In last week's module, we looked at how to determine what laws apply, and more specifically, whether the UCC Article 2 governs a particular transaction. In this week's module, we will assume that Article 2 applies and look at how to determine whether or not an agreement has been reached between the parties. We'll do so by focusing in on three topics. First, we'll discuss mutual assent under the UCC. Then we'll look at the UCC's firm offer rule, which allows merchants to make irrevocable offers. And then we'll finish by looking at the dreaded Battle of the Forms provision of the UCC Article 2, Section 207. So how is a contract for the sale of goods formed under Article 2? Well, like the common law of contracts, the creation of a contract requires the mutual assent of the parties. The parties to the contract must agree to be bound to the terms of an exchange. Usually, this comes in the form of an offer plus an acceptance of that offer, where one party, the offeror, makes an offer to another party, the offeree, and the offeree accepts the offer that the offerer made to her. But all we need to form an agreement is mutual assent, some objective evidence of an agreement between the parties. Now, before we look at mutual assent under the UCC, it's important to recognize the distinction the UCC makes between an agreement on the one hand and a contract under the other. Both terms are defined in the definitions provision of Article 1, Section 201 of Article 1. An agreement is defined by Article 1 as the parties bargain in fact, what the parties actually agreed to, whereas a contract is defined as the total legal obligations that result from the parties' agreement. Under these definitions, the parties contract, the legal obligations of the party, can be both more and less than what the parties actually agreed to. It could be less than what the parties agreed to if some or all of the parties' agreement is legally unenforceable. For example, the parties' agreement may lack consideration and therefore be wholly unenforceable. Or there might be specific provisions of the parties' agreement for which there is a valid defense to enforceability, such as the doctrine of unconscionability. Likewise, the parties' contract, that is, the parties' total legal obligations to one another, can also be more than the parties' agreement. It could be more than the parties' agreement because once the parties agreed to a sale of goods, the UCC implied several terms creating legal rights and obligations for the parties. These implied terms are beyond what the parties actually agreed to. The implied terms, stated differently, are beyond the parties' agreement. They're rights and obligations that were never discussed or contemplated by the parties. Note also that the concept of contract under the UCC is slightly different and somewhat broader than our conception of a contract under the common law of contracts. Under the common law of contracts, a contract is generally understood to mean a set of legally enforceable promises that are made by the parties, a promise being a commitment to do or to refrain from doing something at some point in the future. So the bargain that the parties make under the common law, it must include some exchange of promises, promises made by one party to the other party to do or refrain from doing something at some point in the future. This kind of exchange of promises would also qualify as a contract under the UCC. For example, the parties might make a contract pursuant to which the seller promises to sell goods to the buyer, and the buyer in return promises to pay for those goods. But the UCC does not require a promise as a basis for a contract. A simple exchange between the parties of goods for cash would create a contract under the UCC. All the UCC requires is an agreement of the parties to a bargain. Any bargain, including a mere exchange of goods for consideration, creates a contract under the UCC. Consider the example of a shopper at a supermarket checkout, purchasing goods, paying the store clerk, and walking out the door. There are no promises exchanged between the shopper and the supermarket, but clearly the shopper and the supermarket have reached an agreement on price at least. This bargain, in fact, is the basis of a contract under the UCC, even though there were no promises exchanged between the shopper and the supermarket. In this respect, the UCC's conception of a contract is broader. Both an exchange of promises and a mere exchange of goods for consideration are considered contracts under the UCC. So what we'll look at in this week's module is how agreements are made. Once we have an agreement, there will be a separate question we need to ask, which is all of that agreement enforceable? Is all of that agreement a contract?